everyone. I think we can start our panel on data protection and innovation acceleration. I'm Sophie, the moderator, but I will give the floor to our chair, who will introduce the panel.
With great pleasure. My name is Malte Beyer-Katzenberger. I'm a lawyer, but I also consider myself something else, as we just discussed here on the panel, because lots of lawyers, but lawyers who are also something else. First, a warm welcome to you. The room has been cooled down after the last session. Thanks for being us in Area 42 and not being in Davos or somewhere else. I'm a policy developer at the European Commission at the digital department, which is called DG Connect, for those of you who know the codes of the different departments of the Commission. I'm a lawyer by training, but looking at transversal questions of the data economy. We've been formed as a team in 2012 when big data was still in its infancy, I can say, in terms of the commercial application, and we're now looking at selected questions of the European data economy and trying to keep a connecting view inside the Commission on the various initiatives, and then data protection is an obvious thing to study. What we also do in the team is funding research and innovation actions. Some of them come to Cpdp, as here today. So DataPitch is one of the research innovation actions that we fund as a, can I say, a matchmaking place between startups, small companies that want to provide services on data, and they're looking now for data providers, and also support how to launch and accelerate their business ideas. That's what DataPitch, I think, is in a nutshell. And therefore, I'm very happy that the project has undertaken the effort of putting together this really interesting panel, which is composed of a variety of people here. We're looking at a lot of lawyers who have something else. So I'm starting with Sophie herself, who is an associate professor in Southampton and has been many assignments for the OECD and the Venice Commission in particular. Then Alison, who is also a researcher in Southampton, in the lead for data governance at the university. And Gary, who has been at Hogan Lovells, but now is actually having a private enterprise on anonymization as a service, if I can say it like that. Not as a service. Okay, so as a technology that will support data innovation. And finally, there's Bashara, Hinnawi, on the same, I would say, same kind, so innovation acceleration and supporting startup programs. And finally, Gwendal from the CNIL, French Data Protection Authority, and Paul Francis from Max Planck Institute. A long list, very distinguished panel. I'm very happy, looking forward to listening. What is the order, Sophie?
Just to explain how we will proceed, and then give the floor to the panelists to give a short presentation, and then we'll have questions. So data protection and innovation acceleration, these are big words. Not sure whether they convey the whole message, but they are here because we have been, well, I and with Alison have been working for the DataPitch Action Innovation program funded by the European Commission. And we've essentially DataPitch is creating a Europe-wide accelerator, trying to give money to startups to innovate with data. So we are creating links between data providers and startups, and giving money to startups to solve challenges with data, gently offered by data providers. We have a range of challenges. A first call is actually now closed, and we will have a second one in June. So essentially, the message that we received was that data sharing is good. And that's a message that comes directly from the European Commission. But, and that's a big but, the European Commission also said, and is also saying, I love data protection. So the big question, or the very naive question, I don't know anymore, is how do we do data sharing with data protection? And now that should mean, how do we do data sharing with the GDPR? So I repeat, we want to do some sharing. I can put some nuances here. And we can't wait for the legal academics to guide us. And then I could even include the lawyers, yeah? We want practical solutions because that needs to be happening now. So how do we do data sharing with the GDPR in practice? And by the way, this is just a question that arose looking at the action of the EC in the past few months. How can the EC be so sure that there is a clear distinction between personal data and raw non-personal data? That's also the underlying question. So to address this series of questions, we've got a panel organized in this way. Bashara will kick off the discussion discussing what is open innovation and looking at the perceptions of the players, in particular the startups, how they see data protection. Is it an obstacle to innovation or not? Or do we have other legal obstacles such as licensing? Then we'll give the ball to Gwendal from CNIL, who will give the view of the regulator, telling us whether there are indeed best practices to be compliant and whether anonymization or pseudonymization are part of the answer. Then Paul will follow with a short talk on anonymization, telling us whether anonymization can work. Gary will then take the floor to speak about data protection by design and by default, and explain to us how it is actually possible to both innovate and be compliant. And then Alison will give a brief overview of the lessons learned so far in the context of the DataPitch project, and looking once again at these sharing agreements that we've tried to conclude between, on one side, data providers, and on the other side, startups. So enjoy.
My turn, okay. So hello everyone. First of all, I would like to start by talking a little bit about open innovation, what open innovation is. So in general, open innovation is any kind of innovation that happens outside the company walls or the company borders. And there are several programs that I'm currently involved with. One of them is DataPitch, as we all know. And another one is called Smart Open Lisbon, which brings, for example, the public sector, the Lisbon municipality, some corporates and startups in order to implement products within the city. And there are other corporate accelerations where we bring startups in order to respond to challenges that the companies have. So how do we promote open innovation? Basically, there is no silver bullet there. It's mainly educating, mainly being in cities, in places where the company leaders are, and educating them about why they shouldn't fear open innovation, and why they shouldn't fear sharing data in a safe environment, for sure. Now, if we look at corporates and their data, and we have to understand what is the reluctance. And first of all, the data of a company is one of the most valuable assets that they have. Other than their teams and the regular assets, the data is one of the most valuable ones because they accumulated throughout the years, and it's something that if they share it, they might fear competition, they might fear replication of their solutions and so on, and it's very difficult for them to let go of their, let's call it their baby, okay? So basically our process usually goes is, first of all, we have a first meeting, and the first reaction is, no, I don't want to share my data, thank you very much. But then after explaining all of the benefits about open innovation, why if we take data from X and take data from Y, it's much, you create better solutions and so on. Also for the company in terms of processes, in terms of, let's say, also new offer for the company and growing their business. which is a very important factor. So after they let's say internalize this concept, they say, okay, let's share data. But what they're thinking about is they're thinking about the general data that is actually available and actually people can see it or take it, just in order to try the test. And that is a trick here, because if you say yes to this data and take it, then you will not be able to create good solutions. And the process of within the company to get data out of the company, you have to drill upwards for authorizations and then drill downwards, and it's a whole process that if you eventually get the data and get startups working on it and don't get solutions, then there is no way that you're going to get another okay for the next round. So in terms of data protection, the whole topic here is that data protection helps also, it protects, gives them kind of security to open their data to startups and create this kind of environment. And there are several ways that you can do it. You can do it in a sandbox, for example, where the startups, a sandbox is actually a controlled environment where they share data with only specific people, and it doesn't go out of that contained area. So the logical trend would be, if we look at the whole market, would be starting with, for example, the public sector, where we have open data in public sector, which started from one country and it grew. And then you go to the private sector, where you start with companies that do not have real competition, which is easier for them to give data and create new solutions. And then you go into the corporate arena. Now, first of all, the corporates doesn't want to be first to give out the data. But the problem is that they should be more afraid of being second, because if the competition does it before them, then they will be behind in the market. I don't know how much time I have, but please stop me, okay? So how do data providers and startups see data protection? If we talk about the corporates, I usually have this analogy about data protection being like airport security, okay? You have to have it. It's a hassle, it costs a lot of money, but you have to have it, and you know that it's good for you because it protects your business, protects your clients, and so on. And if we look at the startup side, it really depends on the stage of the startup, because when a startup is in the initial phases, they usually don't really know which data they need in order to get a product market fit to their actual solution. So they start testing, and if they have to go through a whole process of legislation and taking care of all the parts that needs to be taken care of in the beginning, eventually they will end up with data that they don't actually use. So it all depends on the stage they're in, and I think that the question is not whether they will comply, it's when will they be, when is the right time to do that? Okay, so yeah. And last but not least, I would like to just talk about when we encourage open innovation and how the process goes. So the thing is, it's a process that takes time for corporates to buy into and to be open to share data. And I think that we have started it with DataPitch, and as we see the second edition of DataPitch, we have more companies that are able to, are willing to share data. And I think that's we're in a good direction. Thank you very much.
Just before I give the floor to Gwendal, Bashara, can you just repeat one thing? You said that data protection, thanks to data protection, data providers are sharing, are opening their data sets. Is that what you were trying to convey as a message? So we should be grateful to have data protection?
They should be grateful, yes, definitely. They should be, because it's not the Wild West, and it's like it's kind of barriers that will prevent the spreading of their data, basically.
Where is the real negotiation in terms of IP licensing, or?
I think the main difficulty here is the concept, is buying into the concept, and it's letting go of your baby, which is your data that you worked all through the years in order to accumulate it and get it.
So psychological barriers.
Yes, definitely.
Okay, thank you. Gwendal?
Thank you. Hello, everyone. So I'm Gwendal. I work for the French Data Protection Authority. My message will be very simple in a way. What the GDPR says is sharing is caring. It says data sharing is caring for data protection and for a certain number of rules. And it sets a level playing field, so everyone has to follow the same rules and is in a fair competition when you're on the business side. In other sectors, the regulation has never prevented or undermined competition or innovation. I think it's the CEO of a big car manufacturers who said that, talking about the highway code, there's a lot of rules in the highway code, and this has never prevented a lot of innovation in the car industry. I think it's the same in the data world. If you look at all the things that have been happening since 1995 with the directive, I mean, there's been a lot of innovation. So innovation has been there, and there was rules, and the GDPR is there to modernize the rules that were adopted in 1995 at the era of big data, data sharing, and the internet economy. Data sharing means many types of operations. I mean, if you look into it, and of course, we're sitting here here in the Cpdp panel because most of or many applications at least involve personal data and the exchange of personal data. So the EU legal framework is, of course, applicable to all processings of personal data, so it's applicable to many applications of data sharing, and the GDPR has been drafted with this in mind. I mean, it was very clear if you look at all the negotiations at the Parliament, at the Council, what people were talking about at the Commission. Malte can certainly confirm this. People were thinking about portability, innovation, all the new things that you could do with the data, and the specific provisions in the GDPR to foster innovation and make sure that data can be reused to a certain extent while keeping the right balance with the rights and interests of the data subjects. I will give two examples. One of them is, of course, anonymization, which will probably be discussed also later on this panel. With respect to anonymization, the Article 29 Working Party published in 2014 some guidance on anonymization techniques, reminding what are the criteria to meet proper anonymization, and it has detailed a number of techniques that can be used by a company that wants to anonymize data in order to be able to share and reuse that data. So I refer to opinion, I think it's 5/2014, if my memory serves me well. We also discussed the technical limitations of anonymization techniques there. Now, if you look at the GDPR, the specific provisions on further processing to facilitate data reuse or big data applications, possibility to have categories of purposes. You look at Article 5 and Article 6 in particular. The notion of compatible purposes, the notion of reasonable expectations of the data subject, the fact that for some applications of data, archiving purposes in the public interest, scientific or historical research purposes, statistical purposes can be considered compatible. This does not mean that you can do whatever you want, but I mean, there's a lot of leverage that is provided in the GDPR for reuse of data in that context. Of course, there's a strong incentive to anonymize data properly, as I said before, because when you have anonymized data, then it's not personal data anymore, and you can reuse it much more easily, even though you had personal data in the beginning and you've been processing personal data before you produce the anonymized data in most cases. There's also some discussions on pseudonymization and a lot of incentives to use pseudonymization. Pseudonymization has to be seen, first of all, as a good security measure, a leading practice that people are encouraged to implement whenever they want to secure the personal data processing correctly, or if they want to reuse data. It's listed in several places in the regulation, but the most important thing to keep in mind is that pseudonymized data is still personal data. This is very clear in the definition. So you can't just say, I've pseudonymized the data so I can do whatever I want with the data set and I don't need to comply with the rules in the GDPR. Last point, perhaps, when you look at at pseudonymization and the text in the GDPR, a special focus perhaps on Article 6.4, which gives you a list of criteria that can be looked at, that can be assessed to check or to assess whether or not the further processing of data is compatible with the initial purpose for which you have collected the information. I won't go through the list. Please refer to the GDPR and we can discuss this in the questions if you deem it necessary. I want to use the rest of my time to talk about a report that the CNIL published at the end of last year on smart cities. Unfortunately, it's only in French, so perhaps we're promoting French innovation in particular before we open this to the others, but of course you're free to translate the report. It's a report on smart cities, which is called in French La Plateforme d'une Ville, which explores all the possible, new emerging uses, applications that you see in cities today. And what has been, there's been the vertical era of the smart city, then there's been trying to put the citizen at the center with the notion of smart citizen and things like that. And since a couple of years, you see the big data companies of the internet, they're also offering services for smart cities. So we're exploring all of the scenarios and emerging uses in this report. And at the end of the report, there's 4 scenarios that are proposed to foster data reuse, to make it more easy, and that can be taken up depending on what you want to do, some of which require a legal change, so an intervention by the legislator, and others can be done with the current legal framework. So I will just list very quickly the 4 scenarios. The first one is compulsory open data for the private sector. The idea being that if you're a municipality, you are relying today on the private sector to offer a number of services. What does the public get back from this, basically? Is the data going to be held only by this private company, or should you have some kind of open data for the private sector with an obligation to publish certain data sets that everyone can reuse? So this can be generalized, of course, and this public open data for private sector, and the key enabler would be anonymization. Another solution would be to have a kind of, in France we have this notion of general interest data, so kind of augmented general interest data, if you want, where the data would be pseudonymized, given back to the public organization that has asked the private sector to intervene and give a service, and then the public organization also becomes a data controller and has a possibility to reuse the data. 2 other scenarios that are explored in there, which are without any legal change. The first one is developing platforms that hold data sets, and you interrogate the platform, and the platform is going to do the computation for you and hand in the result to you. So at the end of the day, it exists in the health sector, for instance, and it's very useful for researchers, so they don't hold the data sets themselves. there's a trusted third party, if you want, and this trusted third party is going to make the calculation for you. There's a lot of security on the data set that is held by the trusted third party, and you give the result to the one that wants to do some kind of research or new service. And the last one, which is more citizen-oriented, is the citizen self-portability, which is trying to incentivize citizens so that they would exercise their right to portability, which is in the GDPR, and give this back to the public organization to develop new services. So this would be done under the control of the citizen and in the common interest. So this is, I don't have more time, I guess, to go deeper into these scenarios. They're discussed more deeply in our report, which you can find on the CNIL's website. And my final word will be the same as the introduction. Data sharing is caring for data protection. Thank you.
Thank you, Gwendal. Can I take the occasion to ask a question that I have Gwendal and Malte in the same room, sitting side by side? Gwendal, do you have a view on this idea that the Commission had to create a producer rights on raw data to encourage innovation? That this is now buried, as I understand it, but...
Well, I was restraining myself at the introduction, but may I say that I was one of the people who were forced to write something about this data ownership right by Commissioner Oettinger, who had the brilliant idea that the law, the civil law, because he's a lawyer like many of us on the panel, has to be updated in terms of to take account of the digital economy. And if there's value in data, however you measure the value, whoever measures the value, but if we agree that there's value in data for lots of people and there's potential of reuse, the tradability of data needs to be enhanced. So the question was indeed whether this should come through a legal vehicle, a right on data, a right in rem for the lawyers in the room. So a specific absolute right that you can enforce against anyone. The idea has so many downsides and so many difficulties that we are currently not really pushing it further during the mandate of this college. I think that's a promise I can make to the room. And certainly, it would only have applied to non-personal data. That's quite clear in the communication of January. Let me just say two things on what I heard so far. So data collaboratives is a piece I picked up in the Harvard Business Review yesterday. So there's that's probably the term that we like most to exploit the secondary reuse potential of data. And I'll read with great interest the Smart City report, because that's also something we try to foster, so the reusability of data generated in a public-private partnership context. I read yesterday that the Prime Minister of Luxembourg, the country where I live, has met the CEO of Cisco because he believes in public-private partnerships. So that's probably exactly the type of context where we have to be watchful. Where do the data end up that the government, municipalities create together with the help of large tech giants, and that's something we're also looking quite carefully.
Yeah, maybe if I can just add a very short word on this notion of ownership. I think this notion is about to expire. I mean, it's an old notion from the 19th century or the 20th century. Today, everyone is talking about the sharing economy, having a right to use something. They're not focusing on property and ownership and things like that. And the GDPR, in a way, is about this. And is exactly about this. The directive is the same. You have data about you somewhere that is being processed by a controller, and you have a certain number of rights with respect to this data, and the controller has a number of obligations. This is what we're doing also in the sharing economy. This is what people want today. And perhaps if we had this panel in 20 years from now, people would say that the European legislator back in 2016 was completely right, and there will be no more discussion about this, hopefully.
Thank you. Gwendal, if I may, you mentioned quickly the Article 29 Working Party opinion on anonymization. To those who say that this opinion is too restrictive, what do you answer?
Why? I mean, it's a technical opinion. It's an opinion that gives a number of criteria for anonymization and for good anonymization. It's an opinion that discusses different ways to anonymize data. It's not it's not a food recipe. It's not something that says whatever data set you take, you do this and this and that. Put a bit of hashing, a bit of whatever, a bit of data deletion, and it's a very nice anonymized data set. It gives you a quite comprehensive list of things that you can do with a data set to anonymize it, and it's also discussing the failures of anonymization. So what people have been trying with data sets using those techniques, and where they have failed. So you can understand what applies to your data set, and it gives you some criteria, and if you meet the 3 criteria, you can be very confident that you're on the safe side. And if it's not the case, then you need to think a bit more about it, and this is fully in line with the idea you have in the GDPR concerning accountability. Just maybe one more thing on anonymization. The French legislator has given a mission to the CNIL in what is called the Loi pour une République numérique, and we have a mission to certify something around anonymization techniques. So in France, at least, the legislator has been given this responsibility to decide whether or not anonymization done by a data controller is going to be sufficient or not. And we're actively working on this, of course.
Okay, so if you are presented with a crystal ball and you are asking the question, what is going to be the winning recipe in the context of data sharing? Is it going to be anonymization or is it going to be pseudonymization?
It really depends what you want to do with the data. I mean, we're talking about purposes. In some cases, you don't need to anonymize the data at all because it's not relevant. In some cases, so I mean, it really the first question, and this is really the rationale that you have in the GDPR and privacy, and it's all the things we've been doing so far. Is what do I want to do? And once I've answered this question, there is how do I do it? And I just use the data I need for my purpose. And by the way, for engineers, it's also a very good thing, because if you ask your engineers to spend a lot of time coding things that are completely unuseful for your purpose, you're doing a very bad use of your internal resources. So, I mean, these questions are very good for privacy, but they're also essential, I think, for people who want to run their business in an efficient way.
Thank you, Gwendal. Paul will tell us everything about anonymization.
Okay, hi. There. So I'm Paul Francis. I'm a researcher at the Max Planck Institute for Software Systems in Germany. I'm also co-founder of the startup AirCloak, and AirCloak does data anonymization. So here we go. How do I go ahead and just... Okay, so you heard Gwendal talk about some of the benefits in anonymization, and the main one being that anonymized data is not personal data, and therefore falls out of the protections of GDPR. And this is a fantastic benefit if you can achieve it, right? Because then you can just give anybody the data that they may want to get, and you don't have to worry about it afterwards. And in particular, if you think about, for instance, the right to forget, if you're sharing pseudonymized data, and then somebody comes along and says, well, you know, I want you to delete that, then you have an issue, right? Because potentially all the people that you shared with have also to figure out what is that data and delete it as well. So it's quite fantastic if you can have anonymization. Also, Gwendal talked about this Working Party 29 criteria, and he made the statement, you know, if you can satisfy these 3 criteria, then you're anonymous and you're good to go. But deciding, you know, whether these criteria have been satisfied or not is very, very difficult. And I would argue that in essence, nobody, no DPA that I'm familiar with, really knows how to do this, knows how to do it well. Either because they don't have the technical resources, or they may have the technical resources, but not necessarily the time to really do a complete job of deciding if something satisfies these criteria for anonymity. And in fact, we've been through this process with CNIL, who, you know, in many respects did a great job but in many respects fell very short of really understanding if our system, for instance, is really anonymous or not. Can you go? I'm partly here to talk about what we've built as research and now as a product, which is an anonymization technology that we call Diffix. And I won't be able to say much about it here. Mostly I would say if you're interested in anonymization and you're looking for solutions, I have my email address there, so come talk to me or send me an email or contact us. Essentially what we have is a system that you put in front of a raw database, a non-anonymized database, and we provide an SQL interface to the analyst. So you can make, basically you see a normal SQL interface, you can make SQL queries on this data. There's some perturbation involved, but you get reasonable results, so sometimes quite good results. A lot of flexibility, you can work with free text, data types of all sorts. And we claim that what you get out of this is anonymous. I won't say anything more about it just because one can never do it justice in a few minutes, but again, come talk to me if you're interested. So one of the things we've discovered over the last couple years in producing this product and trying to get it, for instance, I mean, you can't really get it certified because nobody has a program yet, but trying to get approval from various DPAs. This is where we've learned this lesson that nobody really knows how to deal with, not really well to deal with anonymity. And so one of the things we've done is really gone down the route of trying to figure out ourselves how we can confidently and concretely say that this is anonymous and provide concrete measures that point to that. And so very recently we've developed a kind of anonymity score. We call it the PCK score or the PIC score. And again, I won't try to describe it, but it's based on the 3 GDPR criteria, and it lets you derive actual numbers, in some senses rather complex numbers, but anyway, it lets you derive numbers that allow you to some extent define the level of anonymity of a system and even compare different systems for anonymity. So this is something that we'll be moving forward with. And in fact, I've been in touch with Amandine from CNIL. And we'll probably be talking to you guys about how this might be used in your own certification scheme. Okay, last slide. And actually, again, getting at the issue of is something anonymous, is it not anonymous, who says so, are they qualified to say so, and so on, is a big problem for us. And so one of the ways that we're trying to deal with this is that we've created a bounty program for anonymity. So basically, we allow people to attack our system using the PIC score that I referred to in the last slide. We derive a measure of how well they've attacked our anonymity, and we actually map that to prizes, right? So we know how much money to give them if they've managed at some level to successfully break anonymity. So it's really the first concrete measure of GDPR anonymity. It's working for us so far pretty well. I think we have a long ways to go in terms of going further with it. But I think it's really an interesting step in order to make this whole notion of anonymity more concrete and not just a bunch of words. And that's really all I have.
Well, that's a good starting point, I would say. Can I go back to one of the statements that you made at the beginning of the talk? You mentioned the CNIL and others, and you said that no one actually knows what anonymization is, but still you are claiming that you are able to contribute to the production of what, anonymized data? Is that what your claim is?
I'll repeat that. I mean, how can I say? It's very hard to point at some technology and say, yes, this has anonymized fully. In fact, there's almost no such thing as really fully, truly 100% anonymized. There's always, something. So it's very, very difficult to know with confidence that something is anonymized for sure, that there's no way around it, that some other discovery later on is going to allow somebody to break that anonymity and so on. So it's very difficult, and I would say that one of the challenges for us is to build up our own confidence, our customers' confidence, and in the end the public's confidence that this is good anonymization and can be called anonymization.
So are you drawing a distinction between anonymization technique that can be applied on data and anonymize data as being the output of the process that can be outside the scope of data protection law?
It's all part of the same thing, right? You have a technique for doing the anonymization, you apply that to some data, and then you produce an output. And yeah, so all of that together has to be, I mean, it could be that something works well for one data set and not well for another data set, you know, as an example. So you have to take all that into consideration, the technology and the data and the output, you know, to declare it anonymous or not anonymous. And this is, again, part of what we're working on.
Okay, and just to sum up your solution, it's only a technological solution, or are you combining other features in order to produce?
No, our solution is really purely technical. You put it in front of really almost any database, and then you can query that data through our system. And you know, our claim is that it's anonymous, but again, this is a claim that people need to look at themselves.
Okay. Okay, thank you very much.
Thank you.
Gary?
Thank you. I want to start by saying it truly is an honor to be here, and I want to highly recommend to everyone in the audience the papers and the research that Sophie and Alison have done on the need for dynamism for data protection is definitely worth looking at. And in fact, what I'm here to talk about is a particular approach to data protection by design and by default that is predicated on what is referred to as dynamic pseudonymization. And to highlight the difference between dynamic and static, the uses of data today are dynamic, and they're challenging traditional static approaches to data protection. There is a study that many of you are probably aware of, where in the US, several scientists, data scientists, secured copies of anonymous databases from census. One was zip code, one was age, and one was gender. In each one of those three data sets, every one was anonymous. The problem is the same token was used to replace people's names. So if it was me, I would be ABCD in the first data set, ABCD in the second data set, and ABCD in the third data set. When you combine the three data sets, you actually reduce the uncertainty or entropy to the level where there's claims that up to 87% of the US population are re-identifiable by name. And so the dynamic use of data threatens and challenges traditional static approaches to protection. And that's why we believe a dynamic approach to data protection by design and by default using pseudonymization makes sense, because then you never claim the data is outside of the GDPR, rather you show that the technical and organizational measures are in place, that it's a permitted use under the GDPR. Next slide, please. So the relevancy and timeliness of this issue is really highlighted by a recent guidance that came out from the Article 29 Working Party. Came out in late November, and I think was initially published, or I first noticed it in mid-December. And in essence deals with, the focus that I will have, is traditional data, historical data, legacy data that's collected up through May 25th based on consent that does not satisfy the new stricter requirements. And so if you don't have consent as your legal basis, what can you do to retain access and use of this data? And typically, we've heard lawyers advising clients they have two choices. They can delete the data, which means they have no access to it again. They can anonymize the data and truly anonymize the data. And if they do so, it will have residual value. It will have general statistical and other relevance that could be used for a number of purposes. But they can never relink it back to individuals or identifying data by definition. The reality is there is a third approach. And that third approach is if you satisfy the requirements for pseudonymization. For those of you who are here at the prior panel, legitimate interest is available. It's not a catch-all. It's not something you just throw things in. But one of the ways that you can support legitimate interest is through pseudonymization. And so this slide is intended to show shock and horror. It's because it should be no surprise that existing governance systems were not designed to support data protection and by design and by default. It didn't exist before the GDPR. Privacy by design did. But if you read Article 25, it's very clear. By default, the data is protected. That's contrary to how data is used today. And by design, only that data that is necessary to support an authorized purpose is revealed. And so that is a requirement that goes to the, caring for the data. Data sharing is data caring. I have to remember that, Gwendal. That's a good one. And it's true, though. If you design the engineering capabilities to protect the data through use, you actually can make greater use. So it should be no shock that existing GRC solutions were not designed to support this. The next slide, if you would, please. This tension here is not new. It's an age-old tension. And you can replace business on the right-hand side with innovation generally. There has traditionally been this tension between the people whose job it is to protect data and those whose job it is to maximize the innovation. But they've been at odds. And the next slide will show why. If the approach of governance, risk, and compliance, GRC solutions, is to protect only, then literally the best you can hope to do is to get up to that wall of absolute complete protection, but you're not going to be able to cross the innovation barrier. Next slide, please. However, if you have incorporated the legal, technical, and organizational requirements into the system, so at the data element level, it protects the data in a way that respects and honors the rights of the data subjects, you can remove just those blocks that are appropriate in a given situation. That enables you to have both defensive and offensive GRC. So this is one approach to data protection by design and by default. And this is the approach that big privacy takes. In this instance, there's 3 steps. Step 1, you delink every single data element. What does that mean? It means you pseudonymize it. You're replacing the data with non-algorithmically derived tokens. There's no means to reverse engineer the value of a token. It's the relationship only. It's a dereference. Number 2, you de-risk the data. So number 1 was pseudonymization. Number 2 is you de-risk the data. There's a principle under EU data protection law of functional separation. If you can functionally separate the information value of data from the means of re-identification, you're given certain incentives. In fact, our interpretation of pseudonymization under the GDPR is very conservative. It literally says, on the one hand, you have information value, on the other hand, you have the means of re-identification, and a key is required to join the two. The reality is, our opinion is if you use the same token again and again, a key is not even necessary. As indicated by the first example, if you're using static tokenization, you don't need a key. You can correlate successive records and actually figure out someone's identity. So the second step of de-risking literally is functionally separating the information value from the means of re-identification. And then step 3 is critical, and we believe is what data protection by design and by default is all about, which is you only provide that level of identifiability. Most processing actually doesn't want identifiable data. The issue is traditional technologies have actually provided that, and there hasn't been a distinction. So let me draw what we see as the differences with design, data by design and by default. Number 1, you separate the information value from the identifiability. You don't make it so that if you want information value, you have to take identifiable data. That's point 1. The second is the access that you get to data are focused on specific use cases. And the third is relinking as possible in controlled authorized conditions. And I want to make it very clear, this is not an as-a-service offering. This is a technology offering that's available to data controllers so they can exercise their stewardship rights. And what this does is it enables you to have greater legal uses of data internally because there are incentives in the GDPR, as Gwendal mentioned, for pseudonymization. And it also increases the opportunity for sharing externally. Next slide, please. So you've taken that tension between the data users, the business innovation on the right-hand side, and the compliance people, those who are protecting the rights of the data subjects, and you've made it not a tug of war anymore. Because the governance controls established by compliance are what are technologically enforced to enable use of pseudonymous data. And only in those situations where identifiability is required and authorized, for which appropriate legal basis exists, is that provided. But oftentimes, pseudonymous data is more than sufficient for the need. The next slide, which is my favorite slide because it blinks, right? On the left-hand side, the bright, vivid blue represents usable data. And below that, to the right, is the dark gray. This is meant to highlight that in a static approach to data protection, using static identifiers, there's a confusion between identity and information value. I get one, I get the other. I can't split them apart. And you actually lose protection at scale, which I'd mentioned earlier, as you start to combine additional data sets. And lastly, the whole value proposition is deterministic, where you rely on knowing that an individual is that specific individual. Now, if you go to the right-hand side, what that's meant to highlight is each individual square is an individual cell of data. Sometimes it's needed, sometimes it's not. If it's not needed, why is it even in the conversation? So you dynamically change identifiers. You will notice that on the left, I call them static identifiers. On the right, they're dynamic de-identifiers. What that means is because the identifier is changing, so if your name appeared, I had the prior example, 3 data sets, and it was ABCD, ABCD, ABCD. Why isn't it ABCD, Q99, and DDID? Now, each of those 3 data sets is anonymous, and unless you have permission to know that ABCD equals Q99 equals DDID, you don't know that, but you haven't lost the ability to relink. And so you actually are separating value from identity. And the more data that's added, the protection actually increases. And for most use cases, it's probabilistic. It's not deterministic, which is more than necessary for the desired use. So the next slide just highlights the difference between the different types of protection and what they were designed to do. So the 3 columns are scalable protection against linkage attacks, or the mosaic effect, the ability to relink, and the last one is increased sharing opportunities. We believe what the GDPR provides in data protection by design and by default actually is the only approach that hits all 3, which is why we think it's the way to increase innovation and sharing. And the next slide highlights the most popular use case. This is oftentimes referred to as multi-party computing, or MPC. And when people think of MPC, they think of homomorphic encryption or maybe differential privacy. But the reality is I can very quickly explain real-world commercial use cases of data protection by design and by default. So you have on the left-hand side in step 1, a blue individual and a green individual. The dark blue boxes represent identifying data. The dark green boxes represent identifying data. The 2 parties agree in advance to a schema, a generalized, probabilistically modified version of their data that is still granular, and they can agree upon the cluster size. In many industries, a cluster of 5 is held to be satisfactory, but whatever that size happens to be, you don't have an individual that is identified in the 2 data sets. So I don't know that John Smith is a customer of yours. What I know is there's 5 people in a category in a data cluster that have similar characteristics. One of them may be John Smith, none of them may be John Smith. But I have reduced my data to a level of identifiability that doesn't reveal who people are, but reveals valuable information about small clusters. Why is that relevant? Because if they both apply the same schema to their data, you can now combine those data sets and have greater knowledge about the combination of the data sets in a non-identifying manner. This uses k-anonymity, L-diversity, and a number of different algorithmic means to ensure that the risk is small enough. And so in doing so, you enable 2 parties to exchange data, enrich the data, have a better knowledge. That data is an asset to them, and you have never jeopardized the individual rights of the data subjects. And then in step 4, with appropriate legal basis, perhaps even consent, you have the ability to give the benefits of this enhanced information back to the original data subjects. So you don't have to conflate or confuse identity and data value. So the next slide shows that you can actually, through data protection by design and by default, leverage non-identifying data. But you can also overcome the limitations on data linking and consent by having controlled relinkability. Again, it's a balancing of interest. This is not a silver bullet. There is no such thing as a silver bullet. And in doing so, you take benefit of, and you take advantage of, to the advantage and benefit of both the data subject and the data controller, of incentives built into the GDPR. And the very last slide simply highlights and enforces that this distinction is timely because data controllers have a one-time opportunity. The guidance that came out says that all the data that you've collected through May 25th, if it's based on broad-based consent, is no longer permissible to possess or process. And so you have to do something. And one of the things companies can consider is whether they have a legitimate interest in maintaining that data for statistical purposes and whether pseudonymization could enable them doing so. So, thank you.
Thank you. Thank you very much, Gary. If I try to sum up, therefore, your answer is therefore both within the technology and also by adding some sort of controls, including legal controls?
Yes, so in order for this approach to work, you have to have a foundation of a knowledge of the law and the compliance, and you set the tools in place so that the individual data controller is the one who's setting the rules. But then the technology automatically enforces those rules. And so the reason the compliance person in the second slide where they used to be tugging war had a smile on his face is because he knows the data that leaves his premise, whether it's to an internal user or an external user, cannot violate the rules that he've imposed on it. So it's a combination of both legal and technical.
Thank you. Alison, the last but not the least.
Hello. Yes, so I'm Alison Knight. I want to take us back to Bashara's first talk to really bring this back to ground about the practical realities of doing this sort of data innovation and data protection concerns. I thought I would, Sophie, if you'd move to the second slide. I just wanted to show you a diagram to really bring back to earth in a very simple way what the project's about and where the barriers or what we're trying to induce. So the whole point of the project is to help evolve a data innovation culture. And in that context, the consortium, who are those four entities on the left-hand side, including the University of Southampton, we're sort of overseeing a process whereby we can get what we call data owners, although I have to say, Sophie and I quickly picked up on that and changed it to data providers. So Gwendal, I know you're listening, data ownership, it's out the window. We did change it, this just got into the slide somehow. So we're trying to get people who've got closed data sets, and we're trying to incentivize them and see if they're willing to share their data in this so-called virtual data innovation lab with these really creative startup SMEs. You know, they've got this great idea about how to use that data, and we're trying to bring the two parties together. Now, it's not that there's an innovation lab, it's not a physical space. In fact, in reality, a lot of the time you actually have the data providers will host the data, and the SMEs, the winning startups would actually access it directly. But it's this notion of a virtual lab to provide a feeling of comfort on both sides, because we're really at the test ground, this in sort of empirical stage of saying, you know, how can we make a sustainable data innovation, open innovation culture, and yet get people comfortable with the legal issues that arise in relation to data sharing. So this goes actually much wider than just data protection issues. Sophie and I have actually written a toolkit which also covers intellectual property rights issues, confidentiality, competition law. But if we're looking at the data protection issues, then I'm just going to split it into two parts. First of all, of course, we have these data providers. They have some data. We're not necessarily contacting their legal department. We're speaking to them and saying, you know, if you give us your data, we've got this really great secure environment. We want to do lots of whizzy things. We're going to get the startups involved. We're going to provide that support. So, in fact, I'm not acting as a lawyer on behalf of the university in this context, or, in fact, for the data owners or the SMEs. What we're doing is to try to give them that support, give them guidance, but ultimately the residual risks do rest with those companies. But we do have a contractual relationship. We actually have the data providers. We have a contract between them and the consortium, a licensing agreement, as it were. And then also we have a contract between the consortium and the SMEs. So there are contractual links. This is a real world environment. What I'm trying to say is it's not just research, it's actually business. And so we're shying away a bit from the research exemptions under data protection, or they could be relevant, but actually we're seeing that these companies, they do actually want these SMEs to provide something useful. So this is an algorithm or something that they can then apply to that data set or other similar data sets to create a real business beneficial outcome. So just briefly then, just in the second half of my 7 minutes, I just wanted to point out some of the issues that arise. So first of all, Sophie, if you wouldn't mind going to the next slide. This is an example of a challenge. So these providers, they come, they have their data. Occasionally, some of them don't have challenges. They just say, hey, I've got this great data. Can you make someone do something really great with it? And we say, no, this is not the right place for you, because we need people to come with a challenge in mind. In fact, talking about dynamic data protection and the concept of dynamic regulation, we're really thinking it's all about this purpose. So everything is very much linked to what is this challenge. But as you can see, these challenges are extremely broad. In fact, we might have an idea of the data, but we've got tech peoples on both sides trying to work out what the metadata, what the categorizations are. So it's very difficult. This is machine readable data, not necessarily something that we could work out ourselves. We have that very first question of, does it relate to a person? Is this personal data? In this case, I've not given you an example of one which does relate to a person, but it's not beyond the realm's possibility to think that something related to supply chain efficiency could actually have an impact, that processing, upon, say, a member of staff if their output was being monitored. There was a conversation earlier today and one about the concept of personal data and the fact that it's dynamic depending on whether data actually relates to a person. And that could be that it has a potential effect upon them. And then we have this issue of, is someone actually identified or identifiable from it? At the very base ground, can they be singled out from that data? Now, ultimately, it may be that under the challenge, what they want people to do, you don't actually need that singled out, let's say, or that personal data. And that could be redacted or taken out. But of course, then a lot of the times when people do provide data sets which relate to people, it's because they want to find out something more about people. They want to maybe do some cross-selling, some cross-marketing. This is what we've typically found. And so there's obviously the question of, if we pseudonymize the data, and we add in lots of mitigating controls around that. So we're not just thinking about the contract, we're thinking about the technology, we're thinking about the organizational. Would that be sufficient for it to not be considered personal data? Now, in reality, some of these companies we approach, as soon as you say, well, yes, you could pseudonymize, you could anonymize, but there's always a risk that data protection may apply. Some of them say, well, I've heard legal departments say, well, hey, we're a non-risk company. Now, that's just a complete, a bridge away from what the GDPR is, which is there is a long tail of re-identification risk, as the other speakers have said. So you can't guarantee that you could ever have anonymized data in the recital 26 of the GDPR sense. So we are left with that problem then, just to bring my thoughts to a conclusion, that really you're trying to guide these people through a process which is so purpose specific. So if data protection did apply, what was the lawful basis upon which that data was originally gathered? What was the purpose? What's the secondary purpose? So this is a challenge example, but actually all these companies will, the SMEs will want to make it much more specific. But this is the whole problem about innovation. We want to find this, reap this unknown value from it. And these companies are trying to reach towards that. And yet at the same time, data protection law and the lawyers want to restrict that use. So at the time, we haven't got some nice techie, product to use it, because we're looking at the very bare bones in this very empirical, starting out phase. But it is an issue, just briefly, because we need to think about how can you minimize data which could be used in an innovation lab? How can they ensure that the secondary lawful purpose, that there is one and that it's compatible with the original lawful purpose? How can you ensure that you've got data protection by design and default? And how can you, in this context where you have startups, SMEs, they don't even know about data protection. This is a problem. In my job, my day-to-day job nowadays, I advise a very big organization, a university, about becoming GDPR compliant. So many people come and they say, well, we don't even know what data protection is anyway. And this is the starting ground, that if you're looking for these really, the next Facebook, the next Uber, or whatever example you want to use, they don't actually necessarily understand what data protection is, and they're way over their head. And this is even when we're sitting in the middle providing that contractual support. So, it's a settling of expectations, and I think that's that's been the biggest challenge that we've faced.
Thank you, Alison. So would you say that there is still, in some ways, an education challenge here that we need to educate more than anything else and explain once again what GDPR is about and that it's about risk?
Yeah, I think totally. I think it's that risk narrative and to help people get comfortable with that, because so many people don't like that, and the SMEs and the startups, you know, they find it very difficult to know, and they may not have the deep pockets to pay for the legal spend. But also, I mean, the bigger the data providers, they don't, you know, they can be quite risk averse when it comes to something where they're thinking, well, usually I'd just make that data open, you know. So it's this provision of closed data sets where there is some reason that previously, as Bashara mentioned, you know, that's my baby, there's some value in there. So I think it's educating, but it's educating at the right level for the right party. That's key, in the right way. Okay, thank you very much. We started with on a very optimistic note. We've got now some nuances. The floor is yours. If you want to ask any question, please go ahead. We are listening to you.
Thank you. Paul-Olivier Dehaye, co-founder of Personal Data IO. I have a question for the gentleman on my left. You presented a system that I think is essentially what Facebook implemented in 2012 following Max Schrems' activism. You can see the Irish DPC audit that was done then, and that's pretty much essentially what they've done. They've centralized all the governance through pseudonymous identifiers, and then they've relegated to logs and live databases all the data in a pseudonymized fashion. The reality of this system is that now it's used essentially to deny rights of individuals. So if you go and you ask Facebook for these pseudonymous identifiers, Facebook does not give them, even though they are random numbers, they're randomly generated. The reason they don't give those identifiers is that later on, they will deassociate the identifiers, they will remove some of the association table, so they can build predictive models based on different facets of your identity, right? So they can use the face and associate with something else, but they cannot link this directly back to the identifier of the individual. So I think that's a problem in the approach, that if you give full control to the data protection officer, but not the data subject over the pseudonymous identifiers, that's too much control to the data protection officer. In particular, in a context where some other members here of the audience will encourage people to move their data around. So the potential for re-identification increases. I don't know if I've explained this well, but.
I appreciate, I don't really hear the question in that, but I can assure you our technology is not Facebook's technology. But you make a very good point, which is you have to ensure. We've received 5 granted patents. The first was in 2015, and then 2016 we had more. And what is unique about our technology that no one else has ever used is those de-identifiers. Literally, if your name appears twice within the same data set or in multiple data sets, it's represented by a different de-identifier. And so when the linkages are broken, it is impossible for either the data controller or anyone else to re-identify it. So I understand your concerns, but I can assure you that the technology that we have developed and are now deploying is not what Facebook had. It has additional safeguards included. I'll start on that. We're a US company. We're here in Europe because the Europeans know how to do data protection right. And the reality is we believe the GDPR represents best practices that companies should have been doing anyways. So it's not finding workarounds, it's actually implementing what the GDPR provides. The GDPR has a very well thought out means of organizational and technical measures that if you put in place, there are incentives and you can have greater use of data. The GDPR is not about anti-data use. It's about a balanced, technically enforced, risk-managed approach to data use. And we believe sooner or later, whether it's through an upswell of the citizens or coming down from the regulators, it was going to happen. And so we actually believe that the GDPR is an innovation enabler, and the clients who work with our technology see it as that. So I see it as a positive, not a negative.
Yeah, well, basically, up to now, it's relatively new. The GDPR is still not in place. For what we have been doing in acceleration programs or corporate programs that we are working with, it's more bringing the startups to the company and working with the company kind of internally, other than the DataPitch that has a different format. So until now, I don't have an example. Any more questions?
I don't really have a question, but I want to make a remark. I must say that this discussion, this forum really worries me. You're talking about organizations, you're talking about companies, you're talking about startups, you're talking about data, but you leave out the person that gave the data to a company or perhaps another organization in order to buy a nice dress or some shoes, and then you're a customer, and you talk about these things that happen without thinking about what does that mean to the person that is providing this data to these companies. That worries me. You may comment.
I mean, just from my perspective, we really are thinking about the person, and I'm sorry that didn't come across just with a shortness of time, but when what we're doing is trying to find out how data can be shared to try to be innovative, but absolutely at the core, what we're trying to do is to make sure that people are sufficiently protected. And in fact, it may be that when you're with the companies, you know, there would be no case at which the person's rights would be affected adversely. And that's why we're relying on things like legitimate interest. There was a panel, in fact, we could have talked more about that. But we do see pseudonymization, for example, it's mitigating harm to that individual, which we then consolidate with contract, with organizational. But you're right, that is looking at it from a very corporate perspective. But underpinning that would be ensuring exactly that there's a lawful basis and there's compatibility. So this is not innovation playground where people's rights are being played away, as it were.
I mean, there's a risk to be incomplete. I mean, we heard a number of avenues how to protect the legitimate interests of the person concerned. But coming back on the question before you, I mean, how many unrealized business opportunities are out there? Maybe some of them were just bad ideas in the first place, because someone had a really truly intrusive idea when it comes to personal data. So with all the different means of making use of some facet of some type of data that are out there, or even work with the individual on the basis of consent. And I invite you to consult also mydata.org as a principle. But some of the ideas may just have been bad ideas in the first place. So it's good that they died at conceptual phase because of data protection legislation. So sometimes it's actually good also to deter certain ideas. Sorry, it's an incomplete, again, answer to your question.
Yeah, and I would add, this is why it's so important to be compliant with the GDPR. The whole purpose of the exercise is not to circumvent the protection, but to use it as a means to sustain innovation. There is still work in progress. I think we reached our time. Thank you so much, and we shall see you around.